Welcome back to another episode with ByrdAdatto. Today, Michael, where are we today?
Versus yesterday.
Yes, we're
um,
still in our homes. It looks like it.
yes, I'm again sitting in the same chair I was for yesterday's video, and will be sitting here for the foreseeable future. Um,
So,
but yes,
are we practicing our social distancing? And if we are, have we gone a little bit further than needed by having our partner in Chicago join us today? Is that helping with the social distancing?
yeah, I believe so.
Yes, good. So we have enough distance. And maybe you should probably introduce this said partner right here in the Chicago area.
Yeah. So Renee Coover is joining us today, and Renee's a partner at ByrdAdatto, and she is our professional speaker of the group of us. And so she is on the speaking team and speaks with us around the country. Renee has a little more credentials than Brad and I, who have untrained speaking abilities. We just tried to share what we know. Renee gave an employment law related TED Talk several years ago, and I think it's ticking up towards 60,000 views. So it's a big feather in her cap, and just a testament to her speaking ability and her knowledge in the space. Renee has been speaking almost daily over the last week since all these new FMLA and sick pay law, the new law has come into play, and all the repercussions relating to that. In fact, Renee was on a conference webinar for ASAPS, an organization that all of us routinely speak at last night. And so today, Renee is going to share some wisdom on the latest and greatest on the employment front with this pandemic in the background, knowing that everyone is making some really difficult decisions.
Yeah, I think one of the reasons why Renee is so perfect for this, among other things, is that her background, unlike ours, is for nearly a decade. Most of her background was in the labor law area, so she comes out with a different sense than you and I, who have dealt in this area. But obviously, Renee has been trained in this area, so we're real excited, Renee, you could join us today and really talk about what is that the expansion of the FMLA, or actually the Families First. Coronavirus Response Act. I think that's what everyone's really trying to understand right now. And maybe you can kind of discuss with us what you've learned today.
Yeah, thank you for having me, Brad and Michael. Always a pleasure. I have been doing quite a bit of researching and reviewing the Families First Coronavirus Response Act, or as we're calling it, FFCRA for short, because it's a mouthful to say. So this bill is providing expanded leave in terms of paid sick leave and paid family leave for employees who are facing really tough situations due to this outbreak and this pandemic. So there are the bill passed the president's desk on March 18th, and as of today, on March 24th, we are still actually awaiting regulations to give some more color to this act and really determine what exclusions or exemptions may come into place. So the regulations have not been promulgated by the DOL yet. We're hoping that the Secretary of Labor in the next few days will come out with some further regulations to really clarify some of the nuances of this act, which have been left undetermined and keeping people on their toes. There's still some unknowns. But as of today, what I can say about the act is that it has two different parts. There's a paid sick leave provision of this act, which allows full-time employees that qualify up to 80 hours of paid sick leave, or 10 days for certain qualifying conditions. And then on the paid family leave side, it allows up to 12 weeks of paid family leave for employees with qualifying conditions. Historically, under the FMLA, in order to qualify for paid or any type of family medical leave, you had to have a serious health condition. You had to be an employee that worked for the employer for at least 12 months consecutively and had logged 1,250 hours. And then on the employer side, to be a covered employee under the FMLA, you needed to have a minimum of 50 employees. So the FMLA traditionally excluded small businesses in general with under 50 employees. And so what Congress has done is created this act to hopefully, in some respects, give additional relief to small businesses. How this shakes out, we'll see. Right now, the act does apply to all businesses with 500 or less employees. Now, of course, there are some exemptions, one being that employers with 50 or less employees can potentially qualify as exempted if they can prove that their business is jeopardized, or the viability of their business is jeopardized by having to comply with this act. How that's actually going to shake out in the regulations, we're still not entirely sure. But the other group or class of employees that are potentially going to be excluded from any coverage, whether it be paid sick leave or paid family leave, are healthcare providers and emergency responders. And I know that a lot of our clients, especially, are in this healthcare industry and in the field. So this may have a real effect on them. There is a lot of banter back and forth at this point as to who is defined as a healthcare provider. And I won't go into the specifics of that, but there are some definitions and some qualifications that I know we'll be talking about more and more as the regulations come out. But generally speaking, if you do qualify as an employer under this act and you have less than 500 employees, then you are tasked with giving paid family leave and potentially paid sick leave to covered employees. And to be a qualifying or eligible employee, you have to fit under certain conditions. One being that you've actually contracted the virus, that you've been diagnosed with COVID-19. Another condition that you are experiencing symptoms of COVID-19, or you're caring for a family member that has experienced those symptoms or been diagnosed. And then I will say one condition that's not directly related to the outbreak, but is related, is that employees may qualify for the paid sick leave or the paid family leave, or both, if they have a child at home that they're caring for that has been ordered to stay home due to a school or daycare closure. So there are a lot of different qualifying conditions for the different types of leave under this act, and this is all being paid for by the employers through tax credits that the IRS is providing back to the employers through their employment taxes. So there is a lot to digest in this act. I could go on for the next hour, but I know we're on limited time. So that's kind of an overview.
Wow, yeah, it's a lot. And I know just on the front lines of me not being an employment lawyer, but being a business lawyer and fielding the calls from our clients, that, they're trying to make real-time decisions with moving target as to what the rules of the game are going to be. And so, it seems that there's been a big movement from a practical perspective for people that just businesses that can't meet payroll, to furlough their employees so that they can still have some healthcare benefits. They can go on unemployment. But, there's some tax credits that come with this law. And Renee, my understanding is that those tax credits only apply when someone has requested and taken leave under the FMLA or under the sick leave provision. Is that correct?
That's our understanding, right? If you are actually allowing employees to get that paid sick or family leave, you could then apply for and receive those tax credits as the employer. Got
it. Okay.
And I think the other thing to add in here is, as Renee, you said, and Michael, it is hard for us. Anyone can pick up the law and read it. The real catch is going to be once the government issues those final hopefully very quickly the regulations themselves, because that allows us truly to dive deeper into how are they going to enforce it. Because you can read the law, but not until you understand how they enforce it, and that's what the regulations will give us the guidance in. And again, as I think you had said this earlier, hopefully in the next few days we will have it, so we can start
Yeah.
really being able to advise our clients otherwise, which is obviously very important.
Exactly. Yes, we are hoping for more clarity in the coming days.
Yeah. And Michael, what are some other reasonable steps you think the employer should consider in this time frame with this new law being in place and trying to figure out, how should they be thinking about this law and what should they be considering?
The best with all the uncertainty, I feel like they need to be focusing on their business and what they can and can't do. If they don't have cash or access to cash in the form of debt, and they're needing to change their staffing, I think they have to make those decisions. So they're either terminating employees so they can go on unemployment, or they're doing the furlough that I mentioned briefly, that allows the employees to, have some immediate relief from on the unemployment side, and then their hope, of course, is they can pick back up and rehire them or take them off furlough soon. I think it gets really dangerous to be waiting around for these laws before they make important business decisions.
Yeah, and I know we'll have another video this week talking more about making business decisions on those type of issues. But for right now, that's what we have to deal with. And I think that's all time we have today. I want to thank you again for joining us, and Renee, thanks for joining us today. And we'll keep our social distancing with you staying in Chicago. But otherwise, thanks again.
Thank you.
Thank you. Take care, everyone.
Bye.